Dear learners, now today I propose to discuss a very important aspect from the topic of the guardianship and custody of minor children. As I have already discussed in detail while dealing with the initial aspect of the topic of guardianship and custody. If you recall, I pointed out with all clarities that under Muslim law, or according to the Muslim law, father is natural father is guardian of the person as well as of the property of a minor. If there is father, in the presence of the father, or no one else can be guardian of the person as well as property of the minor. Basically, guardianship is a kind of the legal responsibility for having the care and protection of the minor child. Therefore, this right of the father arises and continues throughout until the child attains the age of majority or he becomes adult. What is the age of majority? I have already discussed, no need to repeat it. But at the same time, I pointed out that of course, father is a lawful guardian of the person as well as the property of the minor child. But mother is entitled to the hizanat or to the custody of a minor up to certain age. That has already been discussed in detail. In case of minor boy, up to certain, that is the 7 years. In case of the girl, it is 12 years or age of puberty according to the Shia law. Anyhow, from the birth till the termination of the minority of a child, father is a lawful guardian. But from the birth until a specific age, mother is entitled to the hizanat or to the custody, that is for the purpose of rearing and bringing up the child. The mother is required to be directly in touch of the child. Therefore, for the proper upbringing of the child, for the development of the physical and mental development of the personality of the child, proper rearing, proper caring is a must, and that is possible only at the end of the mother, that is the natural mother of the child who has given the birth to the child. Nobody can best person to bring out or to bring up or to rear the child. Therefore, along with the guardianship, mother is allowed to have the custody of the child for this specific purpose. But during this period also, when the child is in the custody or in the hizanat of the mother, even during this period also, father is having the responsibility of care and protection, that is having the responsibility of guardianship, because the maintenance provision for the rearing of the child during the period when the child is in the custody of the mother will be provided by the father himself. It is the responsibility of the father to make the necessary arrangement which under the given circumstance may be necessary for the fullest development of the personality of the child. Maybe child may require so many things, maybe nutritious items, maybe the apparel, maybe the some other environment. So for everything, all the provisions will be made by the father in the capacity of the guardian of the child. However, whatever material things are required for the proper development of the child, for the upbringing of the child, for the rearing of the child, those materials will be applied or will be spent by the mother, because it is the mother who in the given circumstance can understand in a best way what is but requirement at a particular point of the time of the child. Therefore, natural law, that is the Muslim law, having regard to the requirement of the child up to certain age, this right to custody has been granted to the mother, but father will continue to be the but in case there is a dispute between the father and mother over the issue of the child, over the custody issue of the child or the guardianship of the child, normal rule is that mother is entitled to the custody or hijana of the child up to a specific age as per rules of the Muslim law. In normal course of the circumstances, thereafter, on the expiry of that very specific age, maybe 7 year, maybe 12 year, or maybe majority age of majority, thereafter father will be entitled to the custody of the child, and he will become the custodian of the child as well as guardian of the child. But of late, almost in all the developing countries, the issue of the custody or hijanat of the minor has been challenged by either the parent, and the matter has come frequently for disposal before the judicial forum or before the courts. Therefore, when deciding the custody and guardianship issues, the child's best interest and well-being are given the top priority. In ordinary course of the circumstances, everything is going on well, mother is legally entitled to the custody of the child. Rearing and caring of the child will be with the mother. Child will be with the mother, but father will be the guardian of the child, having the responsibility to provide, to make the provisions for all the material things which may in the given circumstance be indispensable for the fullest personality development or growth, physical growth of the child, for the mental growth of the child. But in case the parties are parents are fallen out, or they are not going, their relationship is not well, they have separated from each other, or the resolution of the marriage has taken place, these may be the situation. In such situation, normally the custody of the child is contested. One parent claims that he is entitled to the custody because the best interest of the child will be safe and protected under his care. At the same time, mother may claim that since she is the best suited person to take care of the child, and therefore she is entitled to the custody of the child, not only up to a specific age, even may be entitled, should be made entitled beyond the expiry of that very period. Therefore, courts have been deciding the issue, contested issue of custody and guardianship of the minor child or children, having regard to the well-being of physical, emotional, uh, mental, uh, uh, so best interest theory is applied uh, to decide the issue of custody and guardianship in case there is a contest between the parents or the lawful guardian of the child. Children suffer most throughout the divorce and family dissolution process, because when their parties are not pulling on well, parents are not pulling on well, and there is a dispute leading to the separation by dissolution or otherwise. So, in this situation, the worst sufferer uh, happens to be the minor child of such parents. Therefore, given having regard to the significance of this idea, the Supreme Court has rendered the groundbreaking decision on gender equality that and has tried to bring a balance between the right of father and right of child mother, so far as the custody of the child is concerned. Therefore, of late, the point has been raised, concern has been raised, that under the customary uh, laws or personal laws, father is a lawful guardian and mother is entitled to the custody up to a certain stage. Only then after father, executor of the father will be lawful guardian of the uh, person as well as the property of the minor. In the absence of both, according to the Muslim law, a grandfather, and in the absence of the true grandfather, his executor will be the lawful guardian of the minor. Therefore, the court, in order to strike a balance between the right of mother and right of father, have come out with the decision that why not the joint custody, joint guardianship right. In the larger interest of the minor and the larger interest of the future development of the personality of the minor, why there should not be, why should we follow the customary laws? Because under Hindu law also, because Hindu law is codified on the subject of custody and guardianship under the Guardianship and Maintenance Act 1956. There is section 6, and section 6 basically points out who is the natural guardian of a minor. And according to section 6, under Hindu law also, father is the natural guardian of the minor, but mother will be entitled to the custody up to the age of 5 years. Under Hindu law, this the objection has been raised so many times that why the the point has been raised that according to the section 6, father is the first and foremost guardian. Mother will be the guardian of the person and property of the minor only after the father, means if there is no father, father has died or has renounced the word, or has become otherwise incompetent, only in that very situation mother will be guardian. Under Hindu law, after father, mother is the lawful guardian of the minor. Under Muslim law, only father is entitled to the guardianship. Under no circumstance, even if there is no father, father has died or otherwise has become incompetent to take care of the child, even in that very situation mother is not entitled to the guardianship of the child. Guardianship will go to the next in order, that is the executor of the father. In the absence of executor, it will go to the grandfather, so on and so forth. So meaning thereby there has been consistent objection from various quarters of the society as well as the learned scholar, that since both are the natural parents, father is the natural parent, mother is the natural parent, but in terms of the custody and guardianship, father is given priority and preference over the mother. And this priority of the father over the mother, both under Hindu law and Muslim law, basically is in contravention, prima facie, on the face of the record, it is in contravention of modern gender jurisprudence, as well as in violation of Article 14 and Article 21 of the Indian Constitution. Because father is the first and foremost, after father, mother under Hindu law, section 6. Under Muslim law, only father is lawful guardian, and mother under no circumstance can be lawful guardian in the ordinary course of the circumstances. If there is father, there is a death of the father, even then in that very situation, mother may be there to take care of the child, but custody of the child up to certain age will remain with the mother. After that, even custody of the child will also go to the male member of the family of the father, that is maybe grandfather or his executor. Therefore, it is very natural that when both are parents, both are the natural parents, both are supposed to have the equal care and protection of the child, both may be equally interested in the well-being of the child. Even sometime mother may be more emotionally attached with the child, and this is very practical. Even then, under the customary laws, under the Muslim law, mother is not lawful guardian of the minors under any circumstance. Only under section 19b, the court can appoint anyone as a guardian, including the mother. But so far the structure of the Muslim law is concerned, under the structured Muslim law dealing with the custody of the child and guardianship of the child, there is no place for the mother to become the guardian, as father becomes automatically the guardian of the person and property of the minor from birth to termination of minority. Therefore, under section 6, subclass 1 of the Hindu Marriage Act 1955, Hindu Adoption and Maintenance Act was Hindu Guardianship and Hindu Minority and Guardianship Act 1956 was challenged. In a famous case, Geeta Hariharan versus State Bank of India and others. And section 6 was challenged on the ground of it being violative of Article 14, Article 21 of the Constitution, and it was pleaded by the petitioner that this provision is gender biased because father being the male is given the preference over the mother who happens to be the female, though both are the parents. Therefore, this provision is violative of Article 14, read with Article 21 of the Constitution. This is a stigma on the status of the mother. So many points were raised before the Supreme Court, but Supreme Court tried to justify Section 6 and word after that, because under Section 6 it is given that father is entitled to the custody, father is lawful guardian, natural guardian of the minor, mother is entitled to the custody of the child up to 5 years. However, after father, mother is. So, after father, the word after was given a very technical, mechanical interpretation by Honorable Supreme Court in Gita Hariharan. And court said that word after doesn't mean only after the death. Court held that under the circumstance, if the father is indifferent to the interest of the child, he is not taking the interest in the care and protection of the child, then father shall be deemed to be absent from the care and mother will become will become the entitled to the guardianship of the child, though there may be the father. And in this way, a balance was struck between father and right of the father, but Section 6 was held to be valid, not unconstitutional. The court said that it is a matter of interpretation, and this is the way whereby Section 6 subclause 1, especially word after, should be read and interpreted. But in KM Vinay versus V. Srinivasan 2011, holding that both the parents should be granted the joint custody in order to ensure the minor's child's long-term development. But before going into the further explanation of this theory, this is important to analyze when the mother is disqualified from the schema, because the mother is entitled to the custody of the child, but up to certain age, but under certain circumstances even she cannot be entitled to the custody. Those grounds are in case of mother, another female, if she married a person who is not related to the child within the prohibited degrees by consanguinity, guardianship, the right of guardianship revives on the dissolution of such marriage. So, normally I have told that mother is entitled only to the custody of the child, hizanat, but she can lose even this right if she has married to a stranger after the death of the father, immediately after the death of the father. If she leads an immoral life, because there are evidences showing that mother is not a person of good conduct, since the bad conduct of the mother may have adverse impact over the mind and personality of the child, in the habit of the child. Therefore, if there is a conclusive proof of the fact that mother is immoral, leading a not a good life, good conduct, then she can be deprived of this right and may lose this right, that is right to custody. If she resides during the substance of the marriage at distance from the father's place, this is also one of the grounds leading to the losing of the right to the custody or hizanat. Mother may not be entitled. But mother is not disentitled to the custody in every case of misconduct or bad conduct, but only such conduct as is detrimental or injurious to the overall growth of the child. Thus, if she treats the child with cruelty, neglects it grossly, she would lose her right to hizanat. Poverty such as would also not disqualify her for the main responsibility of the, because the main responsibility of the maintenance of the child is with the mother. If the child has a property, then of course she can provide it with the house and daily necessity out of the property. The true test is the welfare of the child, otherwise, other considerations are subordinate. Criteria for her conduct is relative to the interest of the child and would vary from case to case. So, there are various grounds which can disentitle a mother even to the right of custody or hizanat, and it can go to some other persons. Dr. Paras Diwan, the author of the book, is of the view that after coming into force of caste disciplinary removal, change of religion cannot divest a person of his or her right or property. This view is held by Mullah Amir Ali and other authors. In several cases, it has been held that change of religion by the guardian by itself ipso facto is not enough to deprive him or her of right of the guardianship. But of course, if the change of the religion is likely to have the uh, adverse impact on the growth of the child, particularly with reference to the culture and traditions to be imbibed by the child, then this can also be a ground for uh, disentitling the mother from custody. If the minor is an unmarried girl and is not related to him within his, if non-cognate within the prohibited degree, maternal uncle is available, he should be preferred over the agnate not within the prohibited degree. The object of this Islamic rule is to avoid the custody of a male who may marry the girl. However, this rule is not recognized by the Shias. This rule, according to the Parziva, should not come in the way of handing over a boy to the custody of the maternal uncles.